morning. Welcome to the First District Court of Appeals. We have 3 cases scheduled to be argued this morning. I will call each case. When I do, if the attorneys would please stand, state your name, the party you represent, and your readiness to proceed this morning. The first case is C-24-0668, Preterm Cleveland versus David Yost. Is counsel present and ready to proceed?
Stephen Carney for the State Defendant Appellates.
Sandra Mitchell for the appellate.
Thank you. The second case is C-25-0119, State of Ohio versus Thomas Gray.
Scott Heenan on behalf of the state, ready?
David Hoffman on behalf of Mr. Gray, ready.
And the last case is C-25-0035, State of Ohio versus Eric Thurmond.
Michael Trapp for appellant Eric Thurmond, ready.
All right. We will begin with case C-24-0668, Preterm Cleveland versus David Yost. Counsel, you may come forward. You have 15 minutes to argue this morning. Would you like to reserve time for rebuttal?
Yes, 5 minutes if I may.
You may proceed when you're ready.
Thank you. Good morning. May it please the court. This case is, or should be, a simple procedural case about the 2 things plaintiffs must do and the 2 things a court must do before enjoining several separate state statutes. And these procedural rules are important because they're how we protect all parties in resolving disputes, regardless of whether the topic's consumer protection, environmental protection, or here abortion. And those 2 things plaintiffs must do are, first, identify specifically which provisions they seek to have enjoined, and equally important, they have to state their reasons so the other side knows what to respond to.
Counsel, to what extent does the prior injunction in this case and the prior litigation in federal court inform the inquiry as to what was at issue?
Not at all, Your Honor, because preliminary injunctions and permanent injunctions are different all the time. Sometimes people seek a preliminary injunction because one thing that's happening, say even a business dispute, could be very urgent, so they get a partial injunction on one thing or a broad injunction. But then when it comes to permanent or trial, for example, a preliminary injunction could be based on just a likelihood of success, but for permanent success, you might have to show full merits with a trial. And here, I want to stress—
Even if we accept that as true, what do we do about the fact that the request here, the language was identical? Does that change your answer at all?
Not at all, Your Honor, because let's look at what this language says. If you look at the motion for judgment on the pleadings, and I encourage the court, whether more important than the 3 briefs here or any of the briefs below or anything, that one motion, if you look at every single page of that and look at it through the lens, pick a sample provision, say record keeping, and say, where was the state told you want to enjoin record keeping, and where was the reason so we had something to respond to? You can't find it. If they can give me a page, say, I'll be happy on rebuttal to address it. But they can't and they won't because they didn't ever mention record keeping. They didn't even mention it in the complaint. They just never talked about record keeping. And here's why it's important to give reasons. Because there is a world of difference between making a substantive claim of saying this violates due process or free speech, or this violates this new amendment. That requires one set of evidence and responses versus saying, oh no, it might be perfectly valid standing alone, but it's not severable. It's so glued to the invalid provision we've conceded that they have to fall together. If we, for example, on the merits.
And so then is it your position that you didn't know which issue you were briefing or responding to?
Correct, we didn't. I still don't know. I've read that motion a million times, well, not literally, but a whole lot. And I read it again in my hotel last night, and I cannot find a page that tells me what provisions. But more important, it didn't tell me. Do I have to, for example—
Don't we look at the complaint, though?
No, Your Honor, because Mitsef and this court's Johnson case say you look at a motion because every day in courts throughout Ohio, people file motions for only some of the
Was
counts.
Mitsef a judgment on the pleadings, or was that summary judgment?
It was summary judgment, but they're
that
both—
different?
No, they're dispositive motions. If you're going to say we want a motion for judgment on the pleadings, then you have to say what you want judgment on. But let me also—
Pleadings. So don't you just go back and look at what the pleadings say?
Sure, and the pleadings never mention record keeping. Moreover, they don't ever in there talk about severability. Not once, and you look in the complaint, do they say these other things go down in a package deal. And we look at statutes, not bills. You cannot find one Ohio Supreme Court case or appellate court case where a court has ever said, because there's one provision, everything goes down except the procedural adoption like single
Well,
subject.
doesn't the statute itself, I mean, the severability question is interesting in that the statute itself, 2919.19, bundles together a number of statutes that should be considered in looking at severability.
Right, and that same statute, .19, says in B4, we, the legislature, want all these to stand separately. And so if I turn to severability, let me say this. First, you don't reach severability without having that proper identification, because a court can't call balls and strikes on statutes if the plaintiffs don't even make a pitch. And you cannot find a single case where there's bill-wide relief in a substantive area outside a single subject or 3 readings. No court has ever done it. I've been defending the state for 28 years on state statute, and I have never seen a court do what they're asking you to do today.
But
Never, not
don't
once.
they argue, I mean, I kind of looked at their complaint as potentially reaching the severability issue, but certainly in the pleadings, they seem to be saying, okay, this heartbeat provision is unconstitutional, which
Right.
the state agrees
Everyone
with,
agrees.
and then everything else has to fall
Right, now here's the
because
question.
of that. So that seems to indicate that they're saying it's not severable.
Well, first, the motion doesn't say why, because there's a severability analysis. So if I may turn to that, the 3-part test in Geiger and the statutory instructions in both 1.50 and the severability provision here, there's one per thing about you have to add words to a statute everyone agrees is not at issue. So there's basically 2 issues. What did the legislature intend? And separately, are they capable to function by themselves?
But you said, hold on a second. First of all, you were arguing that you didn't have notice of what they were arguing, and now that you're saying they don't say why. I mean, do they have to say why, or can they
Yes.
just say it's not severable, and then you can respond that it is?
Well, 2 answers. First, you can't say, I want something struck down just because now you start defending. No, you got to tell us why, because after all, look at what the trial court did here. The trial court didn't even agree with them on severability.
Well,
It
isn't
went
their
into merits
position
review.
that you treat this as a whole? And in 2919.19 would lend some credence to that, in that the legislature has bundled all of these provisions together. And then isn't severability a remedy that inures to the benefit of the government, and that the government can say these provisions are severable? So wouldn't it be incumbent upon the government to say, sever the offending provision away from the remainder of the
Well,
bill?
First, Your Honor, the legislature did not bundle. The language of B4 says if anything is enjoined or declared invalid, it shall not affect any other section. So they specifically said, we want these separately. Not only that, but some of these provisions existed for 6 years before this bill was passed. So obviously, they still intended to keep those around. They were pre-existing. And I want to stress that the trial court here did not agree with them on severability. It said, I have to do merits review, so it started off right, and then it went into merits review that they don't even defend. They admit.
Do you
this
agree
isn't
with
a
the
merits
trial
case.
court that in order to do a severability analysis, you have to determine whether each provision is constitutional? Do you agree with that?
No, Your Honor, because you only do a merits review if they make a merits pitch. And I want to mention, up in Franklin County, the same month they asked in this motion, they filed a full case up there with affidavits, experts, and that's how you do it right, with a factual record. In fact, if you look at their motion to stay in this court, they told you, don't go forward here with a merits review because you can't, because you don't have a factual record.
To
You
this
don't
point, are
have-
we litigating the same case in 2 different forums?
In part, Your Honor. In that case, they're doing a factual record, they're doing it right. And I want to stress the practical example, the practical result here. If you do the right thing and do what we ask, nothing happens.
So then
Nothing
is it
harms
moot?
anyone.
Is this case
No,
moot
it's not
if
moot
nothing
because they
happens?
do have a pending injunction. But because the injunctions are redundant, now that one's on preliminary injunction, and we're going through factual discovery, and there'll be an eventual resolution. So it's not moot because we don't know how Franklin County will come out. But what we do know is this: if you just simply send this back and ask them to do it right and follow the normal rules every other litigant follows, they, by their own admission, will not be harmed, nor will any clinic patients be harmed, affected in any way, because there's protection of the same plaintiffs with the same counsel from this Franklin County injunction. However, if you go their way, not only are you doing something radical that no one's ever done before, but you're threatening how courts review environmental laws or anything else, and then we're going to feel obliged to appeal that because we're here because of the effect on all state laws.
Can I ask you,
Imagine-
though, when you're asking it to be sent back, okay, so you're saying the only thing they challenged was the heartbeat provision.
Correct,
State agrees that's unconstitutional.
correct.
What do you envision happening when it's sent back? A severability analysis?
Well, that's up to plaintiffs, because of course the whole point is plaintiffs make a case. We don't have to preemptively guess for them. They can either move forward with the severability analysis, or they can make substantive merits claims if they want to, and then you have to go through that process. Or they might ask the trial court to stay it to see how Franklin County comes out. But that's the answer, is they have to make some showing. And if I may, on the severability analysis.
Before you
two
go on,
parts.
before you go to severability, are you arguing that the complaint, the amended complaint, is insufficient for the court to have undertaken the review of all the statutes? Or are you saying,
Absolutely.
so you're saying both the motion and the complaint?
Well, so, yes, so two things. First, you always look at a motion. This court's Johnson versus UC case said there were several counts, and they said, oh, this motion didn't talk about these other counts. So you reversed. And that's simply settled law. That's MITSEF. That's settled law, dispositive motion. You have to say what counts. People move on certain counts or certain things every day. But second, not only do you have to give reasons, but let's say you spot them that, and you get to severability. If you get to severability, you have to ask, what did the legislature intend, and are they capable of separation? For the intent, this is the most important part. You look at the legislature's stated intent. You don't try to mind read and say, well, their bigger intent or their broader policy, some metaphysical intent. If they say, we intend these to be separate, then the only thing you could do is find a lack of capability, that you can't separate them. You can't say, that's not your real intent. For example, let's say there's an environmental law, and they say, we want to stop pollution. So we've got provisions about air pollution, water pollution, soil, ground pollution, and let's say the air pollution piece is somehow unconstitutional, and someone wants to strike it all down. If there's a severability clause, you can't say, well, your broader purpose was anti-pollution. No, you would say, can we still regulate clean water even if we don't have this air piece? Well, of course we
Counsel,
can.
you're out of time.
Okay,
Thank you.
Good morning, Your Honors, and may it please the Court. I have two main responses to the government's arguments on appeal. First, the government is well aware that plaintiffs have always sought to enjoin the entirety of SB 23, going back to when the
Counsel,
bill...
if that's the case, aren't we litigating the same issue in two different forums?
We are not. Plaintiffs in this case have always challenged the constitutionality specifically of the 6-week ban. That's what our briefing has been about. As far as the rest of the provisions of SB 23, this has always been a matter of severability. Our argument is that those provisions must also fall.
So then you agree that you're raising no substantive constitutional challenge to the remainder of the bill?
That's correct. We've been arguing specifically as to the 6-week ban.
And
this
in that
case.
regard, then, was it in fact error for the trial court to engage in that substantive constitutional analysis on its own?
We think the trial court reached the correct result, but as we noted in our reply brief below, we did not ask the court to address the constitutionality of those ancillary provisions to the 6-week ban. The court instead could have addressed severability first. And we would argue that that is what this court should do on appeal. This court can affirm for any reason, and we would suggest you affirm on severability.
Why are you asking us to do it that way rather than remand it back down to have severability litigated below?
Well, severability has been litigated in this case before.
Well, not really, not the way you're arguing it. The judge found several provisions unconstitutional, right, and enjoined those based on that.
That's correct.
So I think it would have to be looked at as, okay, the heartbeat bill's unconstitutional, and can any of these other provisions stand, right, with it? on their own.
That's the argument we made below, and we think that's how this court should affirm.
But did the judge do that?
The judge did that with respect to certain provisions. The judge did assess severability. The judge did not assess severability in all of the provisions. But for this court's purposes, we don't think this matters. This court can affirm for any reason. And there's no reason to send this back down to just have the parties rebrief what they already briefed, make the court find another decision, which we know is going to turn out the same way. The court, in fact, already considered severability at the preliminary injunction stage when the state had an easier burden to show.
What happens to the permanent the permanent injunction, if we were to send it back, that would go away, obviously. Is the preliminary injunction revitalized, or is there nothing at that
Well,
point?
Again, we think this court should affirm. If the court is considering remanding for the lower court to take another look, I would say two things. First, we would ask the court to confirm that the 6-week ban remains permanently enjoined and the provisions that explicitly cross-reference it. The state is not challenging those. So we'd want to just confirm for the sake of plaintiffs and all their patients that those provisions remain permanently enjoined.
But hasn't the state already agreed that the 6-week ban is unconstitutional?
That's right. I'm just suggesting if this court is considering remand to just confirm that that part of the decision is not being changed.
Well, counsel, isn't, to that point, I mean, they have not appealed that aspect of the court's judgment, right?
That's right. That's right. I'm just saying for clarity for everyone, if you were to send this back down. But the other point I would make is as to the ancillary provisions, if this court were to vacate some portion of the lower court's decision, we believe that would mean that the preliminary injunction comes back into effect. The preliminary injunction was in effect until a final judgment, and to the extent you're vacating part of a final judgment, we think the preliminary injunction should still be in effect. And we would ask the court to confirm that's true, again, just to make sure there's clarity for plaintiffs, their patients, everyone knows what's going on. And SB 23 has been enjoined for years. This case started in 2019 in the federal district court. The federal district court enjoined the entirety of SB 23. For the Court of Common Pleas, they enjoined the entirety of SB 23 at a TRO. And at the preliminary injunction stage, severability was in fact litigated. The plaintiffs asked for an injunction of the whole bill. The state responded, we think these provisions are severable. Only the 6-week ban should go.
What about the argument from the state that you all didn't go through a severability analysis in your briefing?
Sure. We don't think we need to. Our request for relief has been clear throughout. We ask that the entire bill be struck, subject to...
Don't you have to explain why these provisions can't be severed?
Well, we asked for the relief that we asked for. We presented a constitutional argument on the 6-week ban. We asked for the relief we asked for. The state prevented a defense. The state's defense was that that provision is severable, and then we replied. All of these arguments have been fully ventilated at the PI stage and on the motion for judgment on the pleadings. The state even today hasn't pointed to any argument they were prevented from making because of some lack of notice. All of this is out there. The court had it before it. This court has those arguments before it as well, and this court can affirm on the basis of severability here. Now, if it'd be helpful, I'd like to talk about which specific provisions we're actually dealing with here. SB 23 added or amended 17 statutory provisions to the revised code. 5 of those provisions, the lower court did not enjoin. They're not the subject of this appeal. One of those provisions, of course, everyone agrees is unconstitutional. That's the 6-week ban. That leaves us with 11 provisions potentially in dispute here. Now, 4 of those just clarify the scope of the ban. Definition, saying it doesn't apply to ectopic pregnancies, saying it doesn't criminalize behavior of the pregnant woman, and clarifying that it doesn't prohibit the use of contraceptives. Those just don't stand on their own. They have no meaning without the rest of the ban in place. 3 of them are record-keeping requirements, a requirement that all records relating to SB 23 be submitted to the Department of Health, a requirement that pregnant women sign a form if cardiac activity is detected, and a requirement that the reason performing the abortion is recorded.
Are you talking about check and tell provisions or?
So the check and tell provision is not actually the subject of this appeal. Okay. The lower court determined it wasn't before it because it determined that the adjustments to that provision made by SB 23 were merely cosmetic. So while the government talks a lot about the so-called check and tell provision, not the subject of this appeal at all.
Okay.
And then the final 4 provisions just establish punishments for violating the 6-week ban, making a felony for knowingly and purposely performing an abortion without checking cardiac activity, creating a civil action for wrongful death, and then allowing the state medical board to revoke licenses or assess forfeiture.
And counsel, as I understand it, it's all but 2 of these provisions that have been enjoined in Franklin County?
We have noted there were 2 provisions that we think would lead to potentially substantive effect if they were not continued to be enjoined in this case. It's a little unclear because the Franklin County injunction enjoins certain provisions, perhaps subsets of provisions, but then extends to any provisions that can give those provisions in effect.
Do you believe this case is moot, given the existence of the Franklin County injunction?
No. This case is about SB 23. The Franklin County injunction was dealing with, I believe, predecessor statutes to SB 23, and it was making different substantive arguments about the waiting period, about check and tell, these other provisions that are not, that we were not arguing in this case.
That were pre-SB.
I believe so.
Okay.
These cases are, proceeding differently, making different arguments, and the fact that the courts may have issued sort of overlapping injunctions doesn't affect this court's jurisdiction, and it doesn't affect the analysis in this case either.
So with regard to the provisions that you do seek to enjoin that you say are not severable, so there's some record-keeping and enforcement pieces to SB 23. Explain how those are not severable.
Sure. So the record-keeping and enforcement requirements are clearly about furthering the 6-week ban. To give just one example, one of the record-keeping requirements that you have to submit records relating to SB 23, that you have to record the reason for performing the abortion. That last one in particular, the 6-week ban said abortions are unlawful with these health exceptions, and that record-keeping provision is just making sure you're within that health exception. It doesn't explicitly cross-reference it, but they go together as a package deal to further the 6-week ban. The enforcement provisions are even more obvious. 2919.193 makes it a felony for knowingly and purposely performing an abortion without checking cardiac activity. SB 23 created a new punishment for failing to check for cardiac activity that was the same very severe punishment for actually performing an abortion after the detection of cardiac activity. It was clearly intended to prevent any runarounds of the 6-week ban. It was an extremely punitive provision, and it didn't exist prior to SB 23.
But okay, so if the 6-week ban was deleted from that part of the statute, and it allowed a wrongful death action or any sort of criminal liability based on failing to check for the fetal heartbeat, can you explain if the 6-week part of it is severed or is like crossed out, how could that not stand on its own?
Well, the test is whether the statutes are capable of standing on their own. It can't just mean, can the text exist without the other statute?
I understand that.
It has to mean, does it have meaning? Can we further the government's intent in putting all of these statutes together? We would suggest that these bills were all packaged together in such a way, this was the heartbeat bill. This is something about prohibiting abortion after the detection of cardiac activity, and all of these things have to be read together. And you don't even have to take our word for it. In footnote 11 of our brief, we showed that the government, at various other points of this litigation, has described those other requirements as furthering the 6-week ban. All of these things went together.
Is that in this litigation or other litigation?
I believe that's in this litigation. In the description of how SB 23 works, the government said there's the 6-week ban, and then there are these requirements that make it a felony if you don't check for cardiac activity. Those things all further the legislature's intent to ban abortion after the detection of cardiac activity. So we do think all these things go together. We think they all have to fall together, and that's why this court can affirm on the basis of severability.
I have a procedural question for you. So I'm hearing that elsewhere, particularly in Franklin County, litigation has advanced in a much further procedural posture than this case did. So this comes to us on a motion for judgment on the pleadings. These severability questions sound complicated. Would they benefit from a more robust litigated record than the one that exists here?
No, we think severability is a question of law. We think this court can review it de novo, and we don't think we need the factual record that has been established in Franklin County. The Franklin County litigation is still in the middle of discovery. That case is proceeding. If to the extent you would find that the court needed to address constitutionality first, it would probably benefit from that record. But again, we don't think the court had to address constitutionality first. There's no Supreme Court case that says it had to do so, and there are good reasons for thinking that it doesn't. Severability as a concept assumes that at times some constitutional provisions must fall with unconstitutional ones. Otherwise, you just assess everything provision by provision and strike the unconstitutional ones and keep the constitutional ones. Ohio courts also recognize the principle of constitutional avoidance. You shouldn't decide constitutional questions unless absolutely necessary. Here, the court could have simply assumed the constitutionality of the ancillary provisions and then done the severability analysis. You would end up in the same place. We think that's what this court should do here and should affirm the decision of the lower court.
And you don't believe that there's any advantage to sending it back down for the trial court to be able to engage in this severability analysis?
No. Again, the government has presented their severability arguments here. They presented them below. They presented them at the PI stage. They haven't identified any argument they were prevented from making because of lack of notice. All of this has been out there. It's all before the courts. There's no reason to send this back down, ask for another round of briefing, ask for the court to make another decision, and then we're just going to be right back up here in some number of months. This court can resolve this now. It can give plaintiffs and their patients the certainty they need as to what the requirements of Ohio law are, and we can just all move on. If you have no more questions, I can.
Thank you.
Thank you.
Good morning. I know I'm out of time, but if you'll indulge me briefly, I'd like to address why we did not have an opportunity, what the check and tell and record keeping do, and why they're severable, and then what to do going forward. First, we did not have an opportunity because severability, the arguments about the legislature's intent and the large arguments about capability of can they be separate are very different prongs of Geiger. The very first time they cited Geiger and the very first time they presented their intent theory was the reply brief. There's none of that. You can't find Geiger in the opener.
Did you seek to file a cert reply?
No, we
to
didn't, Your
address
Honor, but the very
severability?
fact that that might have been the only way out of this is to say, please do a SIR reply so that we can address a reply is pretty much to admit it wasn't in the opening
Is it
motion.
your suggestion that you were surprised by the concept of severability in the face of a constitutional challenge to state statutes?
Absolutely, Your Honor, and here's why. Because the very month they filed this, they filed in Franklin County with all this evidence. So we thought, oh, they're doing their substantive case there. If they're going to win their substantive case or get an injunction
Well,
there.
that's as to a substantive constitutional challenge.
Right.
But is it the Attorney General's position that the Attorney General of Ohio was surprised by the concept of severability in the face of a constitutional challenge?
Yes, Your Honor, I can't waive privilege, but I was befuddled, confused, because I've been doing this 28 years, and I've never seen someone say, this provision is bad, therefore strike the whole bill in a substantive area, unless they make a severability showing. But if I may show why it actually is severable. Take record keeping. As far as I could tell, I didn't understand whether this was truly an intent argument or a capability argument. Take the easy one of intent. The legislature's intent here says we want to keep whatever we can keep. So you can't step back and say, well, they intended it to be part of this broader cause. We've been doing record keeping before Dobbs for 30 years. This just changed the particulars of record keeping. Could the state want to know which ones are for which reasons and when? Sure, there are all sorts of reasons to maybe do that. And is it capable? Can you say, you can't ban anything, but we still want to record what happened? Of course you can. No one doubts that you can keep records. And as to the check and tell, Your Honor, it is true that the trial court said the underlying mandate you must check, the court said I'm not going to touch. However, the enforcement of don't proceed without checking, the court did enjoin that, and that did exist since 2013. I apologize for a typo where I said 2015 in the reply. It was 2013. So for years and years, they complied with this, and so it was, and easily we know it's capable of enforcement separately because it applied for years before Heartbeat was passed. It applied. People complied with it. So is it capable? Sure. And did they intend to keep it? Sure. That easily fails a severability attack.
Is that a subject of the Franklin County case?
Yes, it is. So, and that's the bottom line. If you send it back, you don't need to add, first, a preliminary injunction doesn't magically revive. That's not how it works. A permanent injunction replaces that. That's black letter law. If they want, the minute you send it down, they can ask the trial court for a preliminary injunction on day one. This court can only give, I don't think an appeal court can do a preliminary injunction in the first instance, but even if you could, you would have to meet the showing of equitable harm. And they
But
can't
the
show.
state agrees here. I mean, the state has always said the heartbeat provision is unconstitutional.
Absolutely.
So the state, I mean, the state's not going to try to enforce that provision.
No, and we're not going to violate a Franklin County injunction. We're not going to do anything that's obviously in conflict with law. So if you send it back just plain, no extra injunction added, they have all the protections in Franklin County on substantive things, and they can ask the trial court to do it, and that's simple, easy.
And what do
If-
you envision when it goes back? Are you envisioning further briefing on severability? Is that what you think that you didn't get?
I think,
the
it's up to them.
opportunity?
It's up to them. If they want to try severability, sure. If they want to switch to merits, sure. If they want to ask the court to stay the case indefinitely and let Franklin go forward, they might do that. That's what we thought they were doing when they brought the Franklin case. And that's the whole point. It's up to plaintiffs. As I said earlier, a court can't properly call balls and strikes if plaintiffs don't even make the pitch. And they didn't make the pitch. The trial court went off into a bunch of merits directions that we all agree were wrong. And so all we're asking is to follow the rules. Because no matter what, even though the merits of this amendment are not before the court, the one thing I think we all know the merit that amendment did not do is it did not create a super abortion exception to the normal rules of civil procedure. All we're asking is that you follow the rule of law, the normal rules of the road that every plaintiff has to meet versus creating this radical roadmap for everyone to strike down a lot of state laws, which will require us to appeal, because I'm not here about just this issue. I'm here because our liquor laws, our environmental laws, none of us would want to see a whole swath of environmental laws get shot down because of one problem with a surprise reply brief bunch of severability attacks. We wouldn't want to see that in any other area. We shouldn't want to see that here. All we're asking is that you follow the law. Let's resolve this orderly. If they want to do that in Franklin County, they can. It's their case to make. They didn't make it. We're just asking you to follow the normal law. Thank you very much.
Thank you. Thank you both for your advocacy this morning. We will take the matter under submission and issue a timely decision. The second case to be heard this morning is C-25-0119, State of Ohio versus Thomas Gray.
Good morning, may it please the court.
Would you like to reserve time for rebuttal?
Yes, and actually a little bit different. I'm going to reserve 10 minutes. I
right.
originally didn't ask for oral arguments case. Mr. Hoffman did, so I'll make my opening portion rather brief. As I put in my brief, the trial court erred when it granted the motion to suppress in this case. And there's really two reasons for that. One is she said, where's the probable cause to do the search? And there, you can find it in two places. Is this court put in State versus Grayson? There's an arrest. If you have probable cause to arrest, you have probable cause to search that vehicle.
Well, doesn't the contents of the vehicle have to be within the reach of the arrestee?
No, because at the point that the arrest was done, the question is whether or not, you don't have to know whether or not you're going to actually take them into custody or if you're going to recite them. That was the point behind Grayson, is that the officer, when they did the search,
Well, that's
Didn't
two
know.
different justifications, right? One justification is the automobile exception, that there could be something unsafe if the person's returning to the car. That's a protective sweep for weapons, right?
Yes.
That is a totally different exception from the search incident to arrest, which is that there might be items within the reach of the person who is being arrested. These are two totally different things that have two totally different requirements.
I think when you look at the facts of Grayson as to the fact that, again, it was very much a traffic offense, and where you were going to find any evidence of that, that's, again, Grayson split that hair a different way. And
Oh,
even
wait,
if
was
you-
that a search of the person or a search of a vehicle?
In Grayson, it was the search of the person's wallet,
Right.
but the law behind it is, I feel, the same. And even if we go away from what was he being arrested for, it's unquestionable that there was a smell of burnt marijuana coming from the vehicle. And under State versus Moore, that gives grounds to search the passenger compartment of the vehicle. And
Except for the judge below said not anymore because marijuana is legal.
it is to a point, but where she was saying, I don't know where the law is that you can't smoke marijuana in a vehicle, it's in the revised code. That was, it's put in my 3780-36D2. You cannot combust, not a passenger, not the driver, nobody can combust marijuana, cannabis, whatever you want to call it, in a vehicle. I guess
me
a
ask you about the
passenger can do
record, though.
edibles, but
Let me ask you about the record, though. I
Mm-hmm.
thought the judge found that he was not smoking marijuana in the vehicle.
she
There was a
she
little
found that-
bit of burnt marijuana that was sitting in there, but I thought that she found that he was not smoking.
I think she found that because of the change in the law, that more was no longer good law. And to the extent that I don't think the trial court can overrule the Ohio Supreme Court, but even if that change by making some recreational cannabis legal, you can't smoke it in the passenger compartment of your car.
The trial court made a factual finding, and I quote, "There was no evidence to show that the cannabis was being smoked inside the vehicle." You haven't challenged that factual finding on appeal, have you?
Actually, when you look at the facts were is that there was, they called it a coddy or a roach, whatever you want to call it, but there was evidence in the vehicle that there was, at some point, somebody had some marijuana that was being smoked because here's the roach sitting in the car.
Did you allege on appeal an assignment of error that this was a clearly erroneous factual finding?
I did not. I mean, I went through the facts, but my point was that legally, that odor was still enough to allow you to search the vehicle under Moore. And
So how do we square that up? The fact that the trial court made a finding that there was no evidence that the marijuana was smoked in the car with your argument about Moore and its ongoing validity in light of the change in the law?
Moore just says that it's just the odor alone. You don't have to have a cloud of smoke come out of the car when you open the door. It's the odor alone gives you the probable cause to search the vehicle.
So now when you smell marijuana, you're not necessarily looking for trafficking, right? You're looking more that somebody is driving impaired.
Well, you could still be looking for trafficking because, again, it allows you to have a small amount of marijuana on your person. But, again, I think that that's not the question here, and it would depend maybe on what the odor that the officer smelled. I don't have an answer for that right now because it's not the facts here before us, but
But what would it be probable cause? I mean, it would be probable cause that the person was driving impaired? Is that what the
that would
smell?
definitely be a possibility. Is that
And then the
person-
search would then be to find evidence of the impaired driving?
Sure, and if you want to go down the impaired route, was it just the roach there? Was there ashes in the tray? Was there more marijuana that was rolled and ready to go in the car? It could be any number of things.
But was there any other indicia of impaired driving? That
In this
was-
case?
Yeah.
Not that I know, it was a normal traffic stop.
So there was a roach,
Mhm.
and it wasn't being burnt, there was no smoke, and there was no indication that he was impaired.
Not during that part of the traffic stop. And again, remember, he was the passenger, not the driver. And again, the passenger cannot combust cannabis in a car either. So again, I think these are all grounds that would have, Moore is still good law. And even if this court were to say Moore is not good law and say that the rules have changed with the passage of whichever Senate bill created legalized marijuana, police are allowed to act on Moore until a court tells them it's not good law. So if they were acting on Moore and they see this and think, there's.
It's a good faith argument.
It's a good faith argument.
And
That
it wasn't
I
raised
did put that in
below.
my brief.
Is that
So-
problematic, that there was no good faith argument raised to the trial judge? And the trial judge didn't even explore good faith?
I don't think she allowed us to, because when Mr. Vick was trying to address her, she cut him off and said, no, I'm not going to hear anything more. And that was when.
The state, I mean, good faith is a pretty good argument for the state. I can't imagine that the state wouldn't insist on being able to make a good faith argument below.
I don't think that Mr. Vick, when he was making his arguments in the summary judgment, knew that she was going to go down the I'm going to find that Moore is no longer good law route. But either way, it would be error for her to say Moore is no longer good law, and I want the police to have known I was going to make that ruling months ago before I made up my mind. It's just not fair. to
So
any-
what, are you saying that even if the state doesn't raise good faith below and the trial judge doesn't sua sponte raise good faith below, that somehow we can raise good faith?
I think I think that in this situation, the factual record that you've got here before you.
Do you
I think
have
she
any case law to support that good faith was not waived?
No, I did not put it that, I did not look into that, no. But again, Moore is still good law. And the police were allowed to act on that. And her ruling on that, her reason for that is that the law changed and she didn't know where. It said that you weren't allowed to smoke marijuana in a car. And it's right there in the statute.
So basically, if I'm understanding you correctly, you're saying that the trial court's factual findings here aren't really relevant. What's relevant is the fact that, so this is based on the legal argument that Moore is still good law.
Yes, Moore is still good law. Until the Supreme Court, I believe, says otherwise, Moore is still good law. And I know that it's been a minute since I looked into this, but a lot of the states, back when legalization was happening before Ohio, I did look into it, and if I remember, only one of the states, and I cannot tell you which one, had actually said that changed the rules, that all the states that had previously found that odor alone gave probable cause, they all stuck with that rule.
I think most of the states require more than just odor. There needs to be other indicia of intoxication, right?
Perhaps arrest for an OVI, but as far as the search, the states that had said that odor gave probable cause, the way Ohio did in Moore,
Which states are you saying have
Again,
said that odor alone allows for a search?
I would have to, that's where the argument went this morning, so I was saying that somewhat anecdotally. I can get you that if you want, I'd be happy to supplement with that.
And counsel, you've gone over your
I'm sure I
5
have.
minutes, but I know that was in response to our questions, so I'll
Sure.
give you 7 minutes on rebuttal.
That's more than enough, thank you.
Thank you.
May it please the court, Mr. Heenan. Arizona versus Gant, I believe, controls in this case, and it indicates that a search incident to arrest exception is based upon two justifications. First is officer safety, and the second is evidence preservation. And if those justifications are not present in the facts, then there's no justification for that exception to the warrant requirement. And the general rule that a warrantless search is per se unreasonable would control that.
Well, wouldn't the evidence preservation justification be present here? I mean, there was a vehicle and another driver that could take the vehicle away. Mr. Gray was going to be arrested. I mean, wouldn't the police want to preserve whatever was in that car?
Well, the evidence preservation justification depends upon the reason for the arrest. In this case, the reason for the arrest was the warrant for contempt of court from Laughlin. And under Gant, it isn't, the justification isn't a concern for the destruction of any kind of evidence. It's the destruction of evidence that would be probable cause, that would be related to the reason for the arrest.
Was he even arrested? I mean, I thought he was just detained in the back of the police vehicle for the officer to determine if she could recite him and send him back to his vehicle.
Yeah, the officer did explicitly say that she arrested him. That was on page 42 and 43 of the transcript.
She said she in fact arrested, but I thought she arrested him after they searched the car
No, they,
and found the gun.
actually, that was how the question was posed to her.
Yeah.
She was asked if the arrest took place after the search, and she was adamant. She goes, no, I had a warrant to arrest. That warrant was to arrest him, and I was executing that warrant when I put the handcuffs on him.
So you're saying, I have to go back and look at the transcript because I didn't catch that she testified that she was, even though she said initially that she was trying to determine if she was going to recite him, that she arrested him based on the warrant for the misdemeanor
That was her,
and
what
not
she-
for based on what they found in the car.
that was correct. She was
Okay.
arresting him for that warrant. Now, she did tell him at the time that she was going to recite him. And she did go back to the police car after he was cuffed. Wait a minute. Yeah, after he was cuffed and talked to the Laughlin people. And they gave her recite information, but she said by that time she knew that they had found things in the car. And she said, no, we have physical charges, she said. And we
Well, right. So it wasn't based on the warrant. It was based on what they found in the car is why he got arrested.
That was her decision. I believe that was in the calculus of her decision not to release him, but she said she took him into custody because of that warrant. And she used the word custody. And
But the
she used
reason
it
why, so I'm just trying to get timing. So he's placed in the back of the police car, and she is trying to figure out if there's a warrant and if she can recite him. And while she's trying to figure that out, they search his car, right?
That's correct.
Okay.
But they search his car after he's handcuffed and in the vehicle.
Yeah, but she, at that point, hadn't determined if she was going to arrest him for the warrant or recite him yet, right? She was undecided.
I
I
believe that's-
wrong?
That's a fair reading, I guess. That's a fair reading.
I'm just asking you if that's what the testimony was.
There was no explicit testimony that she was going to release him based upon her conversation with Laughlin. But that's what she did. She did talk to Laughlin. It could have been to verify the warrant, whether it was still active. I believe that was done before the stop, but it could have been just to verify the warrant
Okay.
after he was arrested. The ratio of officers to occupants was 4-2. After he was removed from his car, he was, again, there was no way he could access those weapons. And also, even if he were to be
Well, what
returned,
about the argument that, I mean, they weren't sure if they were going to recite him? If he was in fact released and recited, he would have been returned to the car, and that could have presented a safety risk to officers. Couldn't they then search the car protectively to determine whether weapons were inside?
that exception requires specific articulable facts of dangerousness. And in the facts, for example, in the reply brief, there are Smith and Jones, there is evidence of furtive movements when the officer has contact with the occupant. And in this case, Officer Carver explicitly said there were no furtive movements. Now, she attributed it to the tint of the windows, but in Defense Exhibit B, Mr. Gray's, the driver's window is already down when she approaches the car. She has him lower the back rear window, and so she has a view inside the car, so she could see whether there were furtive movements or not. And after she receives his driver's license, and she returns to her vehicle with those two driver's licenses, Ms. Reese's and his, she's walking backwards. The camera, her body camera, continues to face the car as she's returning to her car. So she's watching him in a side mirror or right through the open window as she's returning. So she had a good chance to see if there were any furtive movements, and she didn't see any.
Was this something the state even raised below? The possibility that he would be returned to his car and therefore that it needed to search the car for weapons? Was this issue even litigated below?
No, it was not. There are facts about it, but that's a different exception. That's an officer safety exception under Michigan versus Long.
And does the state need to preserve that kind of exception below in
I
order
believe
to
it's
raise it here?
forfeited if it isn't raised, yeah. And the arguments concerning the return to the vehicle don't appear in this case until the reply brief.
Can you talk about why we shouldn't follow more on the marijuana smell?
First, this arrest was not based upon the odor of marijuana.
It was, though. The officer said that was one of the reasons. Well, the search was, she
No,
said.
they asked her, she said it was that burnt coddy. She said anytime it was
Wow.
on
Well,
page
that's-
42 and 40. Go ahead.
Isn't that what created the odor?
No, that actually, the trial court made a specific finding that it was never determined where the odor came from. That was
Okay,
part
so
of the reason.
let me back up for a second. So the officer said that she smelled burned marijuana in the vehicle, correct?
No, she said she was asked if you smelled marijuana. Yes, I did. That was all there is.
So there was no distinction between didn't she ask, do you have marijuana in the car?
She did. And she
And what
attributed
was-
that question to the odor of marijuana. She said, that's why I asked him.
Okay, and then the reply was yes?
Yeah, he showed her that roach, yeah.
Okay,
Yeah.
and that was partially burnt, correct?
Right, there wasn't anything left of it, but there was no smoke coming off of it at the time.
Well, I understand that,
Okay, sorry.
yes. So wouldn't under Moore, wouldn't the smell of burned marijuana give her the right to search the car?
Under Moore,
Yes.
yeah, the odor of burnt marijuana. The case is distinguished between raw and burnt marijuana. If it's
Right.
raw, you can look all over, but if it's burnt, it's limited, I think.
Okay.
Yeah.
Okay. So how has that changed? Now, I understand that the legislature has legalized recreational marijuana. What restrictions are on that when it comes to where and how?
Okay, well, first of all, you can't vaporize or use it in a car. And that's different than the open container law, because an open container law it would be a continuing offense. So if you had an open container in the car, even whether you're drinking or not, that'll be an offense. But this is different. This is the actual use of it in a car that's prohibited, not the possession of it. And so you can possess marijuana in a car and not be in violation of that prohibition against using or vaporizing. So that's one complication to.
So I'm trying to understand your argument. Are you saying that Moore doesn't apply here, or are you saying we shouldn't follow Moore?
You shouldn't follow it. You shouldn't follow it. It would be like enforcing alcohol possession after prohibition. Same thing. And the same with the good faith law. I don't even think they're ticketing for.
Well, probable cause has to be anchored to some criminal activity and evidence of that criminal activity, right? I mean,
Right.
probable cause is the reasonable probability that evidence of a crime is going to be found in a place. So when we're talking about the odor of marijuana, under the previous regime, the Ohio Supreme Court held in Moore that the odor of marijuana in a car created a reasonable probability that evidence of a crime, i.e., the unlawful possession and/or trafficking of marijuana, would be found in that vehicle. Is that assumption altered by the fact that possession of marijuana in a vehicle is now lawful?
Simple answer, yes, it is.
And so what probable cause or what evidence of any crime might the odor of marijuana in a vehicle establish, if any?
If it's burnt marijuana or raw marijuana, Your Honor?
Well, let's go with the facts of this case, a roach, a coddy.
An odor then of burnt marijuana? Because
Yes.
she didn't specify really whether it was, and he may have had an illegal amount of marijuana in there that he wasn't charged with. But anyway, to answer the question is the odor, it wouldn't support probable cause, especially in this case when she testified, the Officer Carver testified that she couldn't tell when that was smoked. She said that it could have been then, or she wasn't able to determine when it happened.
I guess what I'm getting at is the officers are already aware that there is a presence of burnt marijuana in this vehicle. They already know that.
Right.
So what evidence would they be searching for of what crime based on their knowledge that there was an odor of marijuana coming from the vehicle?
They would be searching for an illegal amount, I guess, of marijuana.
All right. And so does the odor of marijuana then support or create probable cause to search for that crime?
Not necessarily, because there could be a legal amount of marijuana in the car.
And is that the same or different before or after Moore?
It's different after Moore.
Why? Because some version
Because-
of the conduct is lawful and some version is unlawful?
That is correct. That's correct. And there's no way to distinguish between the two. So in Gant, with regard to evidence preservation, the evidence has to be related to the offense that the person's being arrested for. And in this case, Mr. Jones was being arrested for contempt of court. And so the trial court made the observation that what kind of evidence of contempt of court could be destroyed in that car that would justify the search. I mean, both justifications don't apply here to a search incident to arrest. And with regard to the odor of marijuana or the presence of the roach, on page 43, it was, the PC to search was due to that burnt marijuana that was found. It was not based upon an odor that the officer alleged she noticed. The odor wasn't mentioned in her reports. It wasn't mentioned in her testimony even until there was a contention over whether she could smell it, whether there was an odor. She didn't know when it was smoked at all. She couldn't tell on page 43 of the transcript. And the roach in State's Exhibit B there wasn't any smoke coming off of it. So it looks like there was no offense that was taking place with regard to the use of marijuana in the vehicle at the time of the stop. If there are no further questions, I would ask that the court would affirm. Thank you.
Thank you.
Jumping to page 43, the officer's answer to whether what she smelled and stuff like that. Question was not smoking marijuana, but what had been burnt at some point. Well, that I can't speak to. I don't know when it was burned. It could have been freshly burned. They could have been actively smoking it. Did you smell marijuana? I did. That's why I asked them, and that's when it was volunteered that they had the Cotty in the car. So where is your probable cause? The probable cause right there is to find more evidence as to whether or not it was what she was trying to figure out, whether it was freshly burned or if they were actively smoking it, which would have been a
And
violation
so
of the
what
law.
evidence would that be? What evidence were they going to find in the car that would tell them whether the marijuana had been smoked in the car or had just been brought into there already burnt? What evidence would that possibly have been?
Could have been that they felt the Cotty and could tell it was warm because it had been freshly burnt. Either way, they had probable cause to go looking for that evidence. And that under Moore is the justification that gave them the right to search this car, which is where they found the other
In
contraband.
compartments, they were gonna search in compartments and under seats and things like that, just to find evidence of whether the Cotty had been freshly smoked or.
Moore says that the odor of marijuana, burnt marijuana, fresh marijuana, as Mr. Hoffman said, it might change where you can search, but it gave them the grounds to search for that car. And whether or not, maybe it wasn't that they were looking for one Cotty that was in the ashtray, like, oh, here's the one we're going to volunteer because it's old. Maybe underneath the seat is where all the other stuff was. Maybe the other 5 joints, the 5 other roaches were under the seat. I don't know. I just know that the odor gave them the probable cause to answer the question that I did not know the answer to and still don't know. I don't know, nor did the officers know when they smelled it what they were going to find. They just knew that that odor gave them probable cause to look to see if there was more evidence of a crime. In this case, specifically, violation of 36, whatever it is, that says you are not allowed as a passenger or the driver to combust or vaporize a cannabis product in a motor vehicle. That really, it's really that simple, that the odor of marijuana alone, under Moore and under the new recreational laws, still
Would it
can't
matter
smoke it in a car.
If it had been, because I think the transcript was a little fuzzy on whether it was raw or whether it was burnt. If it was the smell of raw marijuana, because I think under Moore, you could search the car if you smelled raw marijuana, right?
Sure.
So could you still, now that marijuana is legal, search the car based on raw marijuana?
I think it would depend. I think if you smell raw marijuana and you look and you see that there's clearly a legal amount in a baggie sitting on the seat, okay, that's probably, okay, you found the source of the odor and you stop. But if you take that baggie out and you're like, that's strange, it still reeks really, really bad here, and that's not explained by that legal amount right there, well, now maybe you got grounds to go look to make sure that you don't have a trunk full of marijuana or just more than the legal amount.
But burnt
Burnt
marijuana or evidence of burnt marijuana, you're saying would be indicative of potentially somebody driving while intoxicated?
Or at least, you know, the
Or the
Section
passenger
36
smoking.
doesn't even require you to be intoxicated. It just says
You can't, right,
you
driving
can't
while
burn
burning
it in a
marijuana.
car,
Right.
And that's driver, passenger, anybody.
anybody in the vehicle. And it's not just burning, it's also, I guess, if you vape it or whatever. The only thing that I think under the law that you could do is if you're a passenger, edibles, I'm sure, fine. I think the idea is probably to make sure the driver doesn't get a contact high. But either way, there was PC to search to see if that law had been violated. For that reason alone, the trial court erred when she found that there's no law that was violated. There's no probable cause search for anything. That right there shows that was legally wrong.
Do we blindly follow Moore, or do we just say, well, Moore's the law, we're done? Or do we need to reanalyze this under the fact that marijuana is legal now?
Under this case, I think you just follow more. Now, if we go back to that hypothetical of I get stopped and you see a little baggie there and you're like, what's that? Pull it out and realize, okay, that's where that raw odor of marijuana was.
Then
And
we
the
might not
odor
follow
went
Moore.
away. At that point, maybe that's where you've got a factual situation where you can look at it. But again, I think even then, if that was the decision, that if those were the facts, right now, if a cop is pulling somebody over outside right now and sees that and smells the raw marijuana, I think until a court says, nope, Moore is no longer good law, the officer gets to rely on Moore.
Well, that's the good faith exception.
It is.
Okay.
But
One of the things that Moore requires is testimony by the officer or the person making this smell determination, that they're a person qualified to distinguish the odor of marijuana. Did the officer in this case testify to that effect?
I believe so, but even if not, she said, hey, I think I smell marijuana. Oh, yeah, here is our roach. I think at that point, she smelled it, and the two people in the car confirmed it.
And you believe that's a fair substitute if she did not testify to her
I think
smell
I-
qualifications?
I believe she testified to her qualifications, but even, I mean, to that point, they admitted, yes, it's right here. Here's at least what we're willing to admit to having in the car. So, for these reasons, I would ask that you reverse this and remand this back to the trial court for further proceedings.
Thank you. Thank you both for your advocacy this morning. We will take the matter under submission and issue a timely decision. The final case to be heard this morning is C-25-0035, State of Ohio versus Eric Thurmond. Good morning. Would you like to reserve time for rebuttal?
Judge Kinley, I would like 2 minutes, please, for
All right. You may begin when you're ready.
Thank you. There's two challenges here, a statutory challenge and a constitutional challenge. I want to start with the statutory challenge. The term under indictment in the Weapons Under Disability statute should not be construed to apply to a person in Mr. Thurmond's position who was in drug court, charged with trafficking marijuana, who got a reduced plea to possession of marijuana, a felony 5, whose plea had been accepted by the drug court there, no finding of guilt had been made, and where Mr. Thurmond was granted intervention in lieu of conviction, and where the proceedings were stayed so that he could undergo treatment in lieu of conviction.
But weren't the charges still pending, though?
No, the charges were not pending. And there's only one case that I found, and the state also has only found, is this Eikenberry case out of the 2nd District in 2008, which held that they were pending, but the reasoning of that is unsound and should be rejected by this court. And the reasoning was pretty simple. They just repeated what the trial court says, that the plea is still, the guilty plea had been entered, just like here, but they said because it had not been disposed of by dismissal or sentencing, the indictment remains pending. And that's not correct.
Why
It
not?
shouldn't be followed. Because the indictment is an accusation of a crime. Once the plea has been accepted by the drug court, there's no further accusation of a crime. It's been converted into a plea. It's been resolved. It's gone. It's changed. And
Is it because the person admitted to the crime?
they admitted to a different crime here, possession of marijuana instead of trafficking. But yes, the person admitted to a crime. The indictment, the accusation has been changed. It's resulted in a guilty plea. No longer an accusation. And that's the chief flaw in this Eikenberry case, is that.
So what is the status of the indictment then? In this time period where the individual has pleaded guilty but is awaiting either dismissal or sentencing pursuant to the treatment in lieu of conviction program?
The indictment is gone. It's been resolved. It's of no force and effect anymore. It's been changed into this guilty plea. And a person in drug court is either going to successfully complete drug court, go through the intervention in lieu of conviction, and get his case dismissed.
So he was originally charged with trafficking,
F5 trafficking.
and then it was amended to possession so that he could get treatment in lieu of?
Correct. Yes.
Okay.
So the indictment is no longer there. There's a plea. The case has been resolved. The indictment, the charge in the indictment has been resolved. And it's a one-way street in drug court, either towards successful completion and dismissal of the charge or failure, which then the trial court takes that guilty plea and accepts it and enters it, and then proceeds to whatever sentence it wants.
If we consider what I believe to be the intent of this statutory disability, and I don't want to speak for the state of Ohio, they can speak for themselves as to why they have chosen to disable people in this category, but I believe it's because they think that people facing felony indictments are dangerous. They've made a categorical judgment to that effect. It appears one possibility is that Ohio thinks that releasing people from that particular disability at the time of sentencing would make sense because either the person is going to have their indictment dismissed, it's going to go away somehow, it's going to be dismissed, or they're going to be sentenced, in which case the disability is going to carry forward under a different statutory provision. Are you following me so far, right? The disability is going to change because they're going to have a felony conviction.
I can follow that.
It seems as though if we interpret the law in the way that you want, we're going to be creating some kind of donut hole in this treatment in lieu of conviction category, where people who are awaiting either dismissal or sentencing in this category lose their disability under the law because their indictment isn't pending, but they haven't been sentenced because they might have their case dismissed if they complete treatment. Is that consistent with the statutory scheme that Ohio has created?
Well, I don't know about Ohio's statutory scheme. They got lots of disabilities for mental illness, for felonies of violence, persons under indictment. I think the Brown court pointed out there's only 3 states that do that. I don't want to speak for the statutory scheme, but I can tell you that once they pleaded out and they're guilty, the indictment part ought to go away.
So that would happen even if we weren't dealing with treatment in lieu of. It's for anyone who pleads guilty but hasn't been sentenced yet.
Yes, that logic would be anyone who pleads guilty.
So there's just like so if you're under indictment, you have a disability. If you're convicted of a felony, you have a disability. But if you plead guilty, there's no disability.
I take that back. I'm talking about drug court here and the particulars of drug court, and most of my arguments are based on people in drug court.
Yeah, but what you're saying is that a guilty plea takes you out from being under indictment.
It does in drug court where the court takes the plea and stays the proceedings.
But doesn't that happen often if the court will send someone for a pre-sentence investigation and continue the sentencing?
Yeah, outside of drug court, that happens a lot.
So that this would be universal for anyone that took a plea and wasn't immediately sentenced.
No, because this only applies to people in drug court. The arguments I've got here are only to people who are in drug court, whose convictions, who don't have a conviction yet, proceedings have been stayed while they undergo treatment.
Do you have any authority that we should carve out this exception for drug court?
I'm not, exceptions carve out from what, Judge Bach?
Well, you just said that there was an exception. It doesn't apply to somebody who makes a plea and then there's a gap between the plea and the sentencing. In general, you said that that doesn't mean that the disability doesn't apply. But you're saying that if somebody is involved in drug court, treatment in lieu of, then the disability should not apply during the time that they are involved in that intervention.
Yes, and that's because they're in drug court and they're getting treatment in lieu and their proceedings have been stayed. And the other reasons I was going to get to here about they've got to have treatment in lieu for at least a year. It could be up to 5 years. It would produce an absurd result to say that someone is under indictment for 5 years while they're in treatment in lieu. There are a lot of particulars to the drug court case. I reflectively said yes, but this is limited to people in drug court in this argument here, not in a general criminal case. So I don't know you're carving out an exception. You're interpreting this ambiguous phrase under indictment, Judge Bach. What does that mean to a person who is in drug court, who has entered a plea, trial court accepted it but didn't make an entry, and they're waiting treatment, and they're waiting to see if they're successfully complete intervention. That's the facts here. That's where I'm saying there's no disability.
This is an interesting argument, for sure, but was this even raised before the trial judge? This
It
particular
was.
argument?
I don't know about the arguments. In his motion, the counsel said in his TD 27, page 2, said he's not a felon, he's in drug court. I don't have the motion here, but if you look at it, it's preserved there. That's what I asserted in my brief. I'm saying here now, it was preserved, and that says he's in drug court, he's not a felon.
But the whole idea of under indictment and the arguments that you're making to us really wasn't made to the trial court.
No,
Okay.
they weren't made to the
So
trial court.
is that forfeited then? on
No, I
appeal?
don't think so. He's preserved his arguments in a written motion, TD 7, page 2. He also preserved some of it at the no contest plea. He didn't do as good a job as I would have liked to preserve it, but he because they were focused on the Second Amendment, let's be fair, they focused on the Second Amendment issue.
Right.
But I believe it's preserved, and you can find it at TD 27, page 2. That wasn't fleshed out.
It was touched on.
It was touched on. I didn't, I thought it was interesting, too, that there was a statute argument before we ever get to the Second Amendment. But let me, before I run out of time, just go through the reasons why a person in drug court should not be under a disability. One, there's no active prosecution. The proceedings are stayed. That implies the indictment is not pending. I've already talked about the resolution by the plea. It's a one-way step towards either dismissal or guilt. There's a rule of lenity here, which has to be applied, which is criminal statute are construed in favor of the accused and narrowly against the state.
Can you educate me? I mean, I'm familiar with treatment in lieu of, and you keep saying the proceedings are stayed, which I mean, I guess in some respects they might be, but the person pleads guilty, and then they're put in on this probationary period, right? Is there an actual stay in the proceedings that's filed?
The statute says they're stayed.
They're stayed.
That's in the statute.
Okay.
The court may stay the proceedings.
Okay, so that the person can go through treatment?
Yes, there's no more speedy trial.
Okay.
There's this is a guilty plea has been made but not accepted. Yes, the proceeding, the criminal prosecution is stayed.
Okay, so they can go through treatment?
Right. The point of intervention in lieu and conviction is to avoid person having a felony. So here we're going to interpret it this way to mean, oh, but if you have a gun while you're in this intervention in lieu of conviction, you can get another felony, an F3 felony here.
But wasn't he not allowed to have a gun while he's?
He's not following the rules of probation.
Okay.
He's not allowed to have a gun because he agreed to it on the rules of probation, and that's the state argument that he's dangerous for that.
At what point, I'm somewhat unclear. I know he has a number of different charges in different cases. Factually, at what point was he charged with possessing the weapon under a disability?
After his plea had been accepted in drug court, but not entered, while they went and did a home search, and they found a gun in his kitchen cabinet. But it's after that. It's after he's been granted intervention in lieu of conviction.
All right.
So if I'm understanding you, the difference between any other defendant who pleads guilty and then is sentenced a month or so later and a drug court is the stay that's in place?
It's the whole drug court statutory scheme, which includes a stay, which includes the fact that it can go from a year, it's got to be at least a year of treatment, to up to 5 years treatment.
So you're saying that because the criminal conviction has been, or the criminal proceedings have been stayed in lieu of this treatment, okay, I think I'm following you now.
Well, if you have any questions, I'm happy to answer it. I believe that they shouldn't be construed here to take away a fundamental right, and they shouldn't be construed to take away a Second Amendment right here. We should understand that we're talking about a fundamental constitutional right, and that the term under indictment shouldn't just automatically be construed to take that away. Eikenberry was a pre-incorporation case. They never even thought about or addressed the Second Amendment here. So that's another consideration.
Counsel, you're out of time. Thank you.
Thank you.
Your Honors, may it please the court. I just have a few points I wanted to make. To me, this is so illogical, what's being argued, with all due respect to his argument. But I first want to address, there's a statement that weapons under disability, to apply weapons under disability to a person who pled guilty to a felony under ILC undercuts the purpose of rehabilitative purposes. How can a rehabilitative purpose include putting guns in the hands of someone who's admitted trafficking and using the drugs?
The possession, right?
Yes.
He pled to possession, not trafficking.
In the first case, yes.
Okay.
Yes, he was, the trafficking was dismissed for his plea to possession. But it's a felony possession.
Well, but that's not what he's charged with. I mean, he's not charged with the felony-based disability. He's charged with the indictment-based disability, right?
Yes. I mean, in the very first, the 2022 case, he was charged with felony possession.
I'm talking about the weapons under
Yes.
disability charge. That's what's being appealed.
Yes.
And the state charged him with an indictment-based disability. So it's really somewhat immaterial, whatever he pled to and all of that, like, is immaterial because he's not charged with a conviction-based disability. He's charged with an indictment-based disability.
He was also charged with trafficking again and possession again.
Right, and I understand him not to
And-
be appealing those convictions. He's just appealing the weapons under disability
But the
conviction.
disability is because of the prior conviction.
That's not what the state charged. The state charged him with possessing an unlawful firearm because he was under indictment at the time that he
Yes.
possessed it.
Yes.
So his convictions really don't matter. What matters is what he was under indictment for. That's what the state charged him with.
But to me, this whole argument of saying that when someone is to get the benefit of intervention in lieu of conviction, that could result in dismissal of the case and expungement of the whole proceedings, that to say that they should be allowed to be armed with weapons during this time. It's just an illogical argument. They're
I don't think he's arguing that. I think he's saying that the under indictment disability was not proper. But I believe I just heard him say that his client was not allowed to have guns while he was in treatment.
Yes, well,
So he was basically disarmed, but he's just saying he can't be charged with being under indictment.
because of the rules of probation, that you're notified that you cannot have weapons.
Well, that's what I just asked. Like, he wasn't allowed to have a gun under the rules of probation.
Yes.
Right. So, I mean, that's not what he's saying, is that my client should have a gun. He's saying my client shouldn't be, it's unconstitutional to charge my client for having a weapon under while he's under indictment. Because he's saying he's not under
I
indictment.
was saying, but I was going to say, but then the argument is that he's not under
Right.
indictment.
That's what
which
he's saying.
is another, as a practical matter, that just does not make sense to me. These cases are held open. It's not dismissed. It's not resolved. I know in the brief, he kept saying, no, it's resolved because he admitted.
What happens to an indictment when somebody pleads guilty to an amended charge?
Under ILC,
Okay, I look at this as anytime somebody pleads guilty to an amended charge. Do you think it's different under ILC versus under any other time that somebody pleads guilty?
you brought that up earlier to say, is it creating a donut hole? That if you've pled.
I didn't ask that question. I'm just asking if anytime somebody pleads guilty, especially to an amended charge, what happens to the indictment?
The indictment still exists. It's not dismissed. It's not resolved, especially in ILC. All the possibilities are still there. The person can take advantage of having a complete dismissal. But they also, as in this case, they violated the terms.
But the
So-
indictment, so if the indictment was for trafficking and he pled guilty to possession,
A felony drug charge.
right, so how is that an indictment still in existence? It means nothing anymore because it was his charge was amended and he pled guilty to possession. And that's the argument on the other side.
Yes, I don't see any logic in an argument that he's not under indictment simply because on the books there, he admitted the charge.
Not to what was in the indictment. It was amended,
Well, he was charged with both, I thought.
was he?
Well, even so, I mean, let's take, I realize we're in the criminal arena, but let's take a civil equivalent, right? Let's say there's a complaint that's filed, there's typically an answer, right? And then we get to remedy. So let's say someone files a complaint, very basic complaint, car accident, negligence. Defendant admits the whole thing. I agree, I was negligent, I caused the accident. We would then move to remedy and damages. In this criminal context, it seems somewhat parallel. The state files an indictment, charging instrument. The defendant, by saying, I plead guilty, agrees. And then we move to remedy, sentencing. Is there not a view, which I think the defense is advocating here, that the indictment no longer carries force because it has been conceded, it's been agreed to? The defendant has pled guilty, has admitted the charges, and therefore we're now at sentencing stage, we're at remedy stage. The indictment is no longer an allegation because the defendant admitted to it. Can you address that view?
In this case, with ILC, it is because he admitted the facts of the charge does not mean the indictment is suddenly suspended or gone, because the indictment is there to have the power that if he violates and doesn't complete the terms, then he's going to be sentenced and convicted.
That's what the plea agreement's for.
Pardon?
That's what the plea agreement's for. That's why when you get ILC, you have to plead guilty. So you're locked in,
Yes,
right?
I believe he pled no contest.
Or what,
But admit,
whatever. I mean, you have a guilty plea hanging over your head. So if you don't do your treatment, then you get the sentence.
Yes.
What does the indictment do?
The indictment is still there with the full force until this case is resolved, until you know whether they did complete it. He only got 1 year probation. At the end of the year, it would be the indictment that would be allowing him to be sentenced if he violates. At the end of the year, if he's completely complied with everything, then the indictment loses its force, and there can be an expungement of all of the proceedings. But I don't think the indictment, you could say, is just gone or suspended during this time. That's the whole point of,
Well, in ILC, can a defendant simply just revoke their guilty plea? Can they just take it back?
I don't know that, Your Honor. I've never seen that situation. This is the only Bruin case I've ever read or had this kind of a brief where ILC was applied. Normally, when ILC is granted, it's successful, we don't see it. I'm in the appellate division, so I have not seen any other cases where ILC was unsuccessful and was appealed. I haven't seen someone say, I'm going to take it back. Do you mean they're saying, I'd rather just get sentenced?
Sure. I mean, I'm trying to assess the rigidity and the significance of the guilty plea. If it's something that the defendant can just withdraw without any consequence, then, perhaps that affects the meaning of the indictment. But if we're stuck at guilty plea, then maybe we're moving on to different steps in the case.
But if the defendant withdrew the guilty plea, there still would be the case and the sentencing, and, I mean, you would start over, but the indictment is still there. It hasn't been.
I agree,
Okay.
which is why I'm trying to assess the force of the guilty plea.
Okay.
I'm sure the law will tell us. Yes.
Well, that's what's so difficult is because, I'm preparing and I'm reading all the cases of Brown, Thacker, Skaggs, et cetera, and those are all pending. We don't have the guidance on how the Ohio Supreme Court is going to resolve these issues.
It's going to be a while, unfortunately.
Today, I think they just took in Hall,
Oh,
which I
did they?
believe is Desmond Hall.
Yeah,
Um,
yeah. Well, can you talk about Brown and why Brown doesn't apply to resolve this case? Because that's the under indictment case out of this district.
I believe you're referring where Judge Bergeron said that when a person is at a bond hearing, if the judge states that, you're going to get this bond, but you may not have weapons, he said if that ruling, that entry is not made a part of the record, the state can't argue that they were under any restriction for firearms. And therefore, he says, and I, correct me if I'm wrong, but I think he was saying, you can't say there was any assessment of dangerousness if that's not put in the record.
Right, so under indictment alone, I believe, is what Brown is saying. Indictment's just an accusation. And that does not assess dangerousness in the future, right?
Yes, that's what it says.
Okay, so how is this not governed by Brown?
Because in Brown, the defendant did not admit anything, did not admit that they committed the underlying
So you're
crime.
saying that by virtue of the guilty plea, it takes us out of Brown?
Yes.
But that's not what the state charged, so help me understand that. If there was in fact a guilty plea here, there would have been conceivably a felony disability, which the state did not charge. We have to follow what the state charged, which was the indictment-based disability.
Yes. But under Brown, you didn't have, I think the two are separate. Brown, he was indicted.
How would we know that from the charging instrument in the weapons under disability case, how would we know that there had been the guilty plea? How would we know that this charge is different from Brown?
It is a part of the record, the plea form that he signed. That was,
We would have to look to the treatment in lieu of conviction case to understand that the disability is different.
yes, that he signed a plea form admitting to the charge and all the terms of intervention in lieu of treatment.
So that was part of like the stipulations for the judge to decide the motion to dismiss or something? Were there stipulations regarding this?
I
Like,
can't answer that.
okay.
I don't know that.
We're dealing with a motion to dismiss, right?
Yes.
And you can only look at the indictment and then any, I guess, stipulations that the parties enter into.
Yes, and that's where I was saying
Or the bill of particulars, maybe.
yes, there's the bill of particulars, there's the, to even interpret, to even get into that argument, the basis of the 2022 case where he pled for the benefit of intervention in lieu of conviction is, I say, is a part of the record.
It's part of this record that the judge had in deciding the motion to dismiss. Okay.
I mean, that gets into a whole area where, I don't know if you saw, I had tried to supplement this record.
With the probation
Right.
stuff, not the plea.
And that was not, I understand your ruling, because that was not something, a correction or something.
Wasn't before the judge.
Yes. But I'm jumping ahead. Depending on how all of these cases come out, then I'm thinking that the state is going to have to start entering all these entries. And the thing is, at the time, say at the time he pled for the intervention in lieu of conviction, the state would have never thought, well, we better put that entry in so that in case he violates, he's not going to bring up a Bruin issue. I mean, but I think depending on how these cases come out, that's what's going to have to happen. It's almost as if there'll be a separate, doesn't have to be a separate proceeding, but the state's going to be having to try to put in all of these documents to ward off a later argument on Bruin.
Oh, wait, I thought you can correct me if I'm wrong. I thought the issue was that the probation guidelines that he's not allowed to have a gun weren't entered in this case when the judge decided the motion to dismiss. I thought that was the issue.
Correct.
Okay.
And normally.
Well, what's
they're
wrong with
not.
putting, I mean, how does that burden the state? If you're litigating a motion to dismiss on an as-applied challenge?
They, from how I've looked at it, or what I've been trying to find out, after the person pleads, you're in court on that, they then are walked over to probation and they sign the rules. So then those rules need to be brought back and entered into the record.
When litigating an as-applied challenge on a motion to dismiss in a different case?
Even before, I think it would have to be put in the record to protect the state for this kind of a challenge.
I think it would have to be in this case,
Yes,
which we don't have.
I understand that point.
Counsel, you're out of time if you'd like to wrap up.
Well, if you even get to the issue about the historical analogs, there are plenty, there is so much case law showing that there's a connection between the Second Amendment, the power for the legislature to disarm people who have drug convictions, they're involved in the trafficking, they could be addicts, goes along with the alcoholics and the mentally ill, and I think that is fully supported.
Thank you.
Thank you.
I just want to point out that the state in its brief says that Mr. Thurman pleaded guilty to possession of marijuana, fifth-degree felony, and his conviction was held in abeyance. That's at TD 29, page 2. A guilty plea in drug court is a one-way street. They don't let you take it back. If they did, everybody who runs into trouble in drug court would want to take back their pleas, and there would be an end to that. So it's,
Mr. Trapp, what happened to the 2022 trafficking charge? Was that dismissed?
2022 trafficking.
Yeah, because he pled to possession, but what happened to the trafficking?
The state got rid of the they amended it to a possession, so he could get treatment in lieu.
Okay.
And there's a guilty plea there that he entered. You enter the guilty plea, but the trial doesn't put an entry. Excuse me. You say it in front of the court, but the drug court doesn't enter it in the docket. So it's there, and they keep it in their pocket. And if you mess up, then they enter it, and then we're at sentencing.
Well, the reason I'm asking is the indictment in this case the allegation is that he was under indictment for trafficking.
That's correct. They didn't have a conviction to use against him for disability.
But hadn't they amended that? Hadn't they amended the 2022 trafficking charge had been amended to a possession charge?
In drug court.
In drug court, and he had pled guilty to that, and that conviction was held at abeyance while he was receiving treatment.
He didn't have a conviction.
Therefore, was there still an indictment to trafficking?
There was no indictment. The indictment had been
So could he have
resolved.
been charged with a weapons under disability for trafficking?
No, because he hadn't been convicted yet. He has to have a conviction.
Well, what's the indictment for trafficking? Not for possession, for trafficking. Did
In
that
drug-
still exist?
No, it had been resolved by a guilty plea. It's in there in the court's pocket, ready to use against him if he messes up on.
Okay, I'm not talking about the possession. I'm talking specifically, since this indictment in this case charged that he had the disability because he was under indictment for trafficking in marijuana, right? Are you with me so far?
I'd have to look at the indictment to check you, but he was under indictment. Yeah, that's what I guess that's what it said. You've got it in front of you?
Yeah, I'm looking at the indictment in this case. And it charged him with weapons under a disability because of his pending indictment for trafficking and marijuana.
That's what they said, but he's not under indictment because he pleaded guilty in drug court. The plea had been accepted.
Okay, let's change the facts just a little bit. Let's say that instead of drug court, he had, the charge had been amended to possession, and he pled guilty to that and was awaiting sentencing, okay? What happened to the trafficking charge? I know it was amended, but could that serve as a
He's
basis?
certainly not under indictment for trafficking. If in a regular court, he pleads guilty to possession because an indictment is an accusation, and an accusation has been resolved by the guilty plea.
I think the question might be going to the amendment aspect. So let's say that a person is charged with murder, and the murder count is amended to manslaughter. Is the person still charged with murder?
He's not charged with murder anymore. He's got a plea to manslaughter. And he's got the consequences and the sentences for manslaughter. That's why he does the plea.
Thank you. You're out of time.
Thank you.
Thank you both for your advocacy this morning. We will take the matter under submission and issue a timely decision. Enjoy the rest of your day.